Academics, non-profit organizations and other stakeholders have gathered in Johannesburg, and this for a conference that focuses on land issues, but more specifically labour tenants. Now, the Office of the Special Master of Labour Tenants, together with the University of Johannesburg and the Association for Rural Advancement and Labour Tenant organizations, have joined hands to allow for this conversation to take place, highlighting historical and current struggles of labour tenants and for their rights to be recognised. Now, for more on this, we join on the line by Professor Richard Levin, who's the Special Master of Labour Tenants. Professor Levin, thanks so much for your time. Welcome to Morning Live.
Thank you very much for this opportunity. Good morning, and good morning to all your viewers.
So, Prof, before we go any further, please tell us about your current designation, because I'm sure I haven't heard about it. I hadn't heard about it before this interview was set up. So not too sure how many people actually know about it. But what does it entail? What do you do and for whom?
If I may say that I'm more proud of the designation than the title. But nevertheless, the Special Master was appointed following a protracted lawsuit, which was initiated by labour tenant applicants on Hilton College Farm, which is in Hilton, a famous school near Pietermaritzburg. So these applicants were joined by the NGO AFRA, the Association for Rural Advancement, which is one of the most experienced and well-known NGOs in the land sector in South Africa. And the case originally focused on the claim of Mwelase and others, so it is known as the Mwelase case, and they were claiming land on Hilton College. So when AFRA joined, given the department's failure to bring relief to these labour tenants, it became a class action lawsuit. So they were joined essentially by all labour tenants. And the one part of the case focused on the need to ensure that the department implements its obligations in terms of the Labour Tenant Act, which is one of 4 pieces of land reform legislation passed just after 1994. So eventually what happened in this process is that the applicants pushed for the appointment of a special master. Now, special masters in other jurisdictions are agents of the court appointed by the judiciary to implement the administrative actions which are required by particular pieces of legislation. So my job really is to supervise, monitor, and oversee the implementation of the Labour Tenants Act and to ensure that all labour tenant applicants have their applications processed and relief is brought to them.
So, Prof, you've explained to us, the history and the process of how we got here, but we know that the question of land in South Africa is still a very touchy subject for many. What can you tell us, though, about, this labour tenants and who exactly they are? And if we were to define it very simply, who is a labour tenant and what are the specific challenges that you would say are most prevalent that they face right now?
Well, labour tenancy essentially became the labour relation in the development of capitalist agriculture in South Africa. So the system evolved over more than a century. And essentially, labour tenants were people who were living on land which was increasingly occupied by white people who were engaged in agricultural activity and who, through the protection of the state and its institutions, established a regime of private property. So labour tenants were not entitled to private property in terms of our history of colonialism and apartheid, but they were recognized as people who had access rights to land. And in exchange for that access, they provided labor to the white farmer. This may have been on a seasonal basis, it may have been on a permanent basis, but the remuneration was never set. And in fact, the remuneration was extremely low. So essentially, every farm worker in South Africa has in their family history a history of labour tenancy. So I think one of the challenges, obviously, is that in terms of the law, a labor tenant is defined as someone who themselves, their parent or their grandparent, performed these labor duties in exchange for payment in kind, access to land, and sometimes rations or meager wages. So that is how our agricultural system was built in South Africa. But the law distinguished between labor tenants, farm workers, and farm occupiers. And of course, if we study history and we look at it from a social scientific perspective, and we look at the definition in law, there are always gaps there. But essentially, that is how labor tenancy was defined. But the practice throughout the 20th century and even before there was, as I've indicated, our agricultural system was built on those relations of production, which were essentially free labor by people who occupied the land and were given access to land for their own purposes, to plow and to rear their cattle herds. That really is the history of it. The challenges they face in the contemporary period, obviously the class action lawsuit was brought about because the department was deemed to have failed to apply the law and thereby process their claims and bring them the relief. I think it's important to say that the department did solve claims, and these came out in court. They said they had, in the court process, solved 9,000 claims, but they claimed that using the legislation was wasteful, and they therefore used other programs, particularly restitution and land redistribution. But actually, there is a difference. So if we look at the case law, which obviously must inform the manner in which claims are processed and the law is practiced, the former Deputy Chief Justice, in resolving a particular claim on Goedgelegen, made a determination that the applicants had applied to restitution, but they were actually labor tenants. And he distinguished labor tenancy as being a claim that is lodged by an individual, because the contract between a labor tenant and a farm owner was an individual contract, albeit an innominate contract, an unwritten contract. It was between an individual labor tenant and a landowner. And therefore, each labor tenant applicant should be treated as a household or a representative of a household, as opposed to a community claim. And that means that in the actual application of the Act, in which there is limited case law, it is imperative that we treat each individual application as an application for a specific piece of land, as well as for rights in that specific piece of land. And in order to do so, we must understand each individual's history, and we must quantify the amount of land which they have had access to historically. Now, obviously, once the legislation was passed, there was a lot of opposition within organized agriculture, because they preferred the approach of the other piece of legislation, which was the Extension of Security of Tenure Act, which has been largely used to evict people. So this is one of the key challenges that they face, is if you look at research that was done by the NGO and Kuzi and Social Research Surveys and presented in Parliament in 2005, they demonstrated that 2.4 million people were displaced on white farms, 940,000 were evicted, and only 1% of those through a legal process. So one can distinguish between eviction and relocation, because our experience as soon as we began our work in the field is that most labor tenants have experienced relocations and what we may call forced enclosures, where the land that they had historical access to was fenced off. Now, it's true that in the history of labor tenancy, with mechanization from the 1960s onwards, we had capital substituting for labor, and that led to many labor tenants no longer having access to plowing fields, which often they plowed with the landowners in tandem, but increasingly they were given rations, a 60-kilogram bag of maize, for example, per household head. So these are the challenges they face, is around forced relocations. But the truth is, in the process of this, we have come across many applicants who have been subject to the most appalling human rights abuses. We recently, in August, held a Healing of Memories workshop. And in this workshop, Labour tenants were given the opportunity of engaging in their specific histories, and they revealed the most appalling allegations of abuse, where their human rights were trampled on. And indeed, if one looks at the historical maps which we are producing, their land has been systematically reduced. They've been moved in many cases from high potential land onto rocks, literally rocks. They've lost masses of their cattle in the process. So these are the grievances of Labour tenants. These are the challenges that they have had. They need their claims to be resolved in a way in which they are given reasonable pieces of land in terms of their historical access rights, which are confirmed by the Constitution in the manner in which the Labour Tenant Act articulates its principal aims, which is to bring relief to Labour tenants, to provide them with security of tenure, and to give them land rights.
And no doubt, very important conversations, Prof. But when can we expect feedback on the resolutions and a way forward or future plans?
Well, we are going to be finalizing the declaration of this particular Labour Tenant Assembly later today. So then obviously we will be able to share that with you and your viewers. And we are expecting a call for a moratorium on evictions and relocations. We are expecting resolutions which will pertain to the need for the department to give full support to the work of the Office of the Special Master, to work with it, to work in a spirit of cooperation, to utilize the capacity of the department to process the claims in a manner which is consistent both with the law and the Constitution of our country.
Well, Prof, thank you so much, and looking forward to that, because it will certainly be very important. But thanks so much for your time, Professor Richard Levin, Special Master of Labour Tenants, speaking to us there about a conference that is currently underway here at Constitution Hill in Johannesburg.